Okay, good evening, everyone, and welcome. I'm Roger Mosey, the Master of Selwyn College. It's nice to see so many people here on a very cold night in Cambridge, and thank you very much for coming if you're here in the Quarry Whitehouse Auditorium, and also if you're joining us online, you're equally welcome. Thank you very much for being here. And the subject tonight is one of great significance, and especially as we near Holocaust Memorial Day, and that is how society accounted for and sought to punish the people responsible for one of the greatest crimes in history, the murder of 6 million Jews by the Nazis during the Second World War, part of their unspeakable persecution of a wide range of groups and individuals who died at their hands. Now, our speaker tonight, Jon Silverman, and I worked together in the 1980s and 1990s in BBC Radio, and a really dominant theme of that time on our news programmes, and especially well covered by Jon, was the emergence of Holocaust awareness, and then the belief that there must be a reckoning, that the people responsible should not be able to live their lives in the UK without facing justice. And then we saw the passing of the War Crimes Act of 1991. It's a very contentious piece of legislation. It led to a really big parliamentary battle, and then the setting up of investigations and a limited numbers of coming to trial. But after all that huge amount of media coverage and political storms and judicial processes, it all came in the end to very little. And I think it's one of the failures of journalism and often of society that we don't look at what happened next. We don't seek to follow up and understand some of the lessons and what they tell us about the legal system and our politics and our society. So that's why it's really important that Jon has written this book with Robert Sherwood, Safe Haven, the United Kingdom's investigations into Nazi collaborators, and the failure, as Jon puts it, of justice. So Jon is a Selwyn alumnus as well. As I said, a former BBC Home Affairs correspondent and an emeritus professor at the University of Bedfordshire. And he's going to speak to us for around about 20 minutes or so. Then I will ask him a couple of questions, but it will be mainly over to you here in the audience. And if you do want to send us a question online, you can email me master@sel.cam.ac.uk, and I will put your question to Jon later on. But now, Jon, if you'd like to tell us about your book and about this very, very important subject.
Absolutely, yes. Well, thank you very much, Roger. And I'm very grateful both to you and to the college for giving me the opportunity to talk to you about this book, Safe Haven. It's got a longer subtitle, but time is short. This is a period, an episode of our comparatively recent British history, which has actually gone largely under the radar. Roger mentioned the War Crimes Act, and there is a whole fascinating other talk to be done about how the War Crimes Act came into being and the constitutional row between the Lords and the Commons, and it was forced onto the statute book. And anyone who's interested in that sort of backstory can do no better than to read a book by the late David Cesarani called Justice Delayed, which came out in 1992, and it deals with that whole period of the 1980s. And the purpose in writing this book was to take the story on. What happened after this contentious piece of legislation came into being in 1991? And an 8-year period which followed right up until 1999 has largely gone unnoticed by academic scrutiny, media inquiry, certainly the knowledge or the understanding of the wider public, even though it was a big story at the time. And the two research questions which triggered the book were, one, how is it that out of hundreds of investigations that took place, because when the War Crimes Act came into being, 274 people living at that point in England and Wales, and another 17 in Scotland, came under investigation. But there were only 2 prosecutions, one which failed because the suspect had Alzheimer's disease, and 1 conviction. So one of the research questions was, how is it out of this Huge enterprise, hundreds and hundreds of investigations by police. There were legal inquiries by the Crown Prosecution Service and the involvement of Treasury Counsel who had to advise the Attorney General on whether there should be prosecutions. How is it that the sole outcome of this process was one conviction? And the second research question was, well, who were these people that came under investigation? And what was the strength of evidence that was looked at? Now, I'm going to deal with the second question first, which may seem a bit perverse, and we'll come on to the reasons why there was only one prosecution. But who were these people? I'll give you a couple of brief case histories. One, a man who was thought to have been the strongest case for prosecution when the War Crimes Act was passed in 1991 was a Latvian called Haris Svikeris. Now, Svikeris was a senior commander, a battalion commander, in one of the most notorious nationalist, anti-Semitic militia operating in Eastern Europe during the war, called the Arras Commando. The head of the Arras Commando, Victor Arras, was finally, he actually was arrested in the British zone of Germany after the war, but somehow he managed to escape. And he was eventually convicted in Germany in the 1970s and sentenced to life imprisonment. And this man, Svikeris, who lived in Milton Keynes, was so senior that at times he deputized for Arras when he was on other duties. And I'll just read to you a little comment that was made to me, which I include in the book, by the then head of Scotland Yard's War Crimes Unit, a man called Eddie Bathgate, Chief Superintendent Eddie Bathgate. And he said, Svikeris was a powerful case, and I would cheerfully have put him on the charge sheet. The more the War Crimes Unit investigated him, the stronger the case got. There was no dispute about identification. He was a volunteer and admitted during the interviews that he was present when massacres took place without an actual confession of guilt. Moreover, as I said, he led the unit when its head was away. But he wasn't prosecuted. The Arras Commando was guilty of more or less eradicating the Jewish community of Latvia by the end of 1941. And a lot of information gathered at the end of the war by war crimes units set up under Stalin. The NKVD, the forerunner of the KGB, were tasked with sending units into all those areas which had been under Nazi occupation to take down names and evidence against people who'd committed, collaborators who'd committed war crimes. There was a lot of evidence about Svikeris gathered at the time and considered by the Crown Prosecution Service, but he wasn't prosecuted. I'll give you another example. A man that maybe some of the older people in the audience might remember because it got some media attention at the time. Svikeris was completely under the radar. I knew about him at the time, but his name was never really in the public domain. A man in Scotland called Anton Gaikas, a Lithuanian, again, a senior commander in a Lithuanian battalion, the 12th Auxiliary Lithuanian Battalion, which committed horrendous massacres both in Belarus and Lithuania, and whose crimes were mentioned during the Nuremberg trial. Gaikas worked for the National Coal Board. He was quite a senior manager of the National Coal Board, living in Edinburgh in the 1980s. And again, there was strong speculation that he was going to be charged. He very unwisely fought a defamation action against Scottish Television, who did a couple of very, very good documentaries about him and the crimes committed by the battalion during the war. And he took them to court for defamation, and he lost. And a High Court judge in Edinburgh said that on the evidence, he was clearly satisfied that Gaikas was a war criminal. but he wasn't prosecuted either. The reasons that neither of these two people were prosecuted, I think, probably goes to the heart of how the Crown Prosecution Service in particular, and I separate them out from the police because the police war crimes unit did as good a job as they were allowed to do. They went all over the world. They took evidence from I don't know how many different countries. But the Crown Prosecution Service, under the influence of what's known as Treasury Counsel, these were the senior lawyers who had to advise the Attorney General on whether there should be prosecutions, because these cases were so exceptional that only the attorney could authorize a prosecution. And in effect, and this is one of the arguments that we make in the book, that the lawyers separated these cases out from the Holocaust. Roger mentioned briefly in his introduction about the growing Holocaust consciousness in the 1980s and 1990s. The Holocaust really is on the margins of these investigations. What the lawyers were looking to do was to mount what they would consider to be a normative murder prosecution, using exactly the same criteria that they would use in any conventional murder prosecution. So what do I mean by that? Well, I mean finding live eyewitnesses who will give evidence in court in front of a jury. Now, these were cases, obviously, of crimes that had been committed nearly 60 years before, and the witnesses were inevitably going to be elderly and infirm, and all of them living abroad. So that was always going to be a very, very tough ask. The other criterion that the lawyers imposed, which I was totally unaware of until the jury was sent out in the one case that did get to a full trial and there was a conviction. I was in the press gallery at the time, and the police handed the press a little note setting out the criteria for prosecution. And one of the criterion completely surprised me because it said only those who were in a position of command would be considered for prosecution. Now, the War Crimes Act itself is a very short bit of legislation, and it makes no mention of the status of anyone to be prosecuted. It just says anyone who committed murder or manslaughter between 1939 and 1945 on territory controlled by Germany was eligible for prosecution. So this command criterion surprised me and was imposed because the lawyers felt that they would have more responsibility for the crimes rather than a foot soldier. What's interesting, though, which runs counter to how the CPS viewed it, in the one case that did get to a conviction, none of the evidence that was offered against him involved his role as a commander. And he was only, basically, he was the equivalent of a desk sergeant in an English police station. So all of the evidence relied solely on his individual culpability. So there's a kind of disconnect there. The other interesting criterion, which was never disclosed at the time, and surprised me a great deal, and still does, was the fact that they were only looking for cases where the victims were Jews. Now, many of these people that I'm talking about, these are Eastern European collaborators in places like Belarus, Ukraine, the Baltic states, and so on. Many of them killed thousands of non-Jewish people, whether they were partisans or suspected of being close to partisans. But they weren't interested in prosecuting any of those cases. The reason being, according to Treasury Counsel, was that a jury might think that somebody who wasn't Jewish might have been a partisan, or somebody that was supplying evidence to the partisans. Therefore, they would be less, quote, innocent than a Jewish man, woman, or child who clearly would have no reason to be on one side or the other. They were just victims and they were slaughtered in their thousands. So these criteria, I think, are very interesting because I think they establish in a way that these cases were separated in the legal thinking from the wider kind of tableau of the Holocaust. And there is one other thing that I think still irks me in a way, and this is not a polemical book. I should add that there isn't an argument in here that there should have been more prosecutions, but there could have been more prosecutions. In a way, it's a kind of piece of reportage, but very detailed reportage. But there was one thing where I think the Crown Prosecution Service and Treasury Council did make a serious mistake. An inquiry was set up before the War Crimes Act came into force under two very senior lawyers. And they were the ones who recommended that there should be a change in the legislation. And they said, look, under normal legal rules, it often takes a long time for a case to go from charge to full trial. And we're dealing here with people who are elderly, infirm, etc., etc. The witnesses are all going to be in the same sort of state. Therefore, there should be some speed, some haste between charging somebody and bringing them to a full trial. In the one case that I mentioned, which was prosecuted, but the man had Alzheimer's, there was an opportunity to bring the case to trial much, much quicker than actually happened. Admittedly, he was 83 when he was prosecuted in 1995, but he was in perfectly good health and mental health as well. By the time it got to a trial, well over 2 years later, at the Old Bailey, he was already failing. He was nearly 86 at that time. Had the lawyers moved more quickly, they could have brought him to trial maybe 6 months after he was prosecuted, And given the strength of the evidence against him, I think it's almost certain that he would have been convicted. So I'll probably leave it there because I've gone into some of the meat of the book, but I think I've given you the sort of many of the bullet points. I think Roger was asking me why these people hadn't been prosecuted much earlier when they were young men, which is a good question because most of them came to this country in the aftermath of the war. Many of them had claimed to be Poles, having fought with the Free Polish Army. They weren't actually Poles, many of them. They were from Belarus and other states. But once the Cold War had started, the focus really switched away from looking back at the war and trying to discover whether there were Nazis living in this country, except for a period between 1950 and 1952, when after a number of MPs began asking questions in Parliament about who were some of these people that we'd admitted, an inquiry was set up by MI5 called Operation Post Report. And some 200,000 Eastern Europeans were called in for questioning at police stations around the country. The interviews were carried out either by immigration officers or police officers, and this was supposedly an attempt to try and find out if any of these people had actually been Nazi collaborators. But of course, by 1950, the Cold War was well underway, and the people who carried out the interviews were really only looking for people that were pro-communist. They weren't interested in people that had been Nazi collaborators. And there's a long interview in the book with somebody who was still alive in the 90s when I started investigating these cases, who's now dead, who carried out many of these interviews. And he said it was really a fig leaf exercise. We weren't looking for Nazis, we were looking for people that were pro-communist. So once that was out of the way, there was no real interest in these people until the 1980s, when allegations began to surface that there may have been many Nazi collaborators admitted to this country, and that triggered the investigations, the War Crimes Inquiry, and the passage of the War Crimes Act in 1991. So I hope I've given you there a précis of the book, and we can move on to the Q&A.
John, take your seat there, and thank you very much for that very clear exposition. I'll come on to the legislation in the 90s in a moment. I just want to develop a bit what you were saying at the end there about why there wasn't a great surge of prosecutions or legislation or anything in the 40s and 50s. And if any of you have seen the excellent TV series, The Rise of the Nazis, the last series, the one that ran last year, had a number of people who had been former Nazis who then became intelligence assets for either the Americans or other Western powers. So are we really saying that in the 40s and 50s there was a sense that the greater battle against the Soviet Union overcame any sense of seeking justice for people who had been Nazi operatives?
Yeah, I mean, it's an interesting point about the use of these people by intelligence, because I started this research thinking maybe I would find evidence that some of these people had been agents for either MI6 or MI5, and that was one reason why they were never prosecuted. I have to say there is no incontrovertible evidence. We did find evidence that a couple of Caucasians who came to this country with the support of MI6 weren't prosecuted, but it's impossible to say, there's no empirical evidence that they weren't prosecuted because they were under the protection of MI6. But I think the substantial point is that by the 1950s, most countries, including those countries who were much more intimately, who had been occupied by the Nazis, were not that interested in going back over the war and prosecuting Nazis. I mean, Israel, which probably had the strongest reason to be looking for Nazis, was not really interested in relitigating, if you like, the Second World War until Eichmann was abducted and then put on trial in 1960. So we weren't alone in that, but I think there was a feeling the war was over, it was done. Churchill had said in 1948 we should draw a sponge across the past, no more trials in Germany, and people had moved on.
You say it's not a polemical book, but let me ask you the big underlying question. Do you think at the end of it there was a lack of will to prosecute and do this? So even though you get the upsurge of awareness of the Holocaust and the evil that people took part in the 80s, in the 90s, did people not really feel it was worth the candle at that point?
Well, yeah, to a certain extent. I think, going back to the passage of the War Crimes Act, there were a lot of people who were opposed to it for various reasons. They said it was retrospective legislation, enabling people who hadn't been British citizens at the time the crimes were committed to be prosecuted. I think, if I can use the word legal establishment, there wasn't a huge amount of enthusiasm for pursuing these cases. I mean, they were duty-bound. The lawyers obviously were duty-bound to pursue cases because the Act had become law. I think the Attorney General, up until 97, when there was a change of government, Sir Nicholas Lyall, was not particularly enthusiastic for the war crimes legislation. So you could say, yes, it needed incredibly strong reasons to prosecute, and the reasons not to prosecute often seem more powerful.
Okay, and looking at the details then about why people weren't prosecuted, you said that first of all there was the sense that you needed to have eyewitnesses and to have a regular murder type level of proof. Isn't that right, that there should, if you're going to convict people of murder, there should be proper full process?
Yeah, a good point, and that's one reason why I say it's not a polemical work. It's not arguing that these people should have been prosecuted by changing the normative rules of murder prosecutions. However, when you look at some other countries, I mean, as we know, Germany is still prosecuting, 100-year-old Nazis. I'm not necessarily in favour of that, but they often rely on documentary evidence. Many of the prosecutions that have taken place in other countries have relied largely on documentary evidence. Now that is inimical, if you like, to English common law, and I'm not suggesting that that should have been subverted in order to do that, but there were other ways, if you like, of looking at these cases. And I think the idea that you were going to find enough cases where there were live eyewitnesses, well enough and compos mentis enough to actually give evidence in court and come to this country was always going to be a very tough ask.
The other thing you mentioned was that there was this criterion which isn't in the Act of a command position. Isn't that right? Some people would argue, because if you were commanding people to do things, you then take the moral responsibility. If you are simply following the orders you have been given, it's a classic debate about ethics and responsibility, but if you are simply a desk sergeant, do you have that responsibility and should you be charged?
Well, no, I mean, I think, the principle everybody had individual responsibility. And the other thing that this command criteria did was to make it favourites, if you like, for prosecution were going to be older by the time, because if you were in a position of command, you were likely to be older than those foot soldiers that were under your command. And if they were already older, the chances that they already had Alzheimer's or whatever was going to be increased as well. So I think it was a principle. It wasn't deliberately designed, I think, to limit the number of prosecutions, but it did have consequences.
I'm going to bring in the audience for questions in just a moment or two, so can you signal if you'd like to ask a question, and I will ask a couple more questions while we then prepare for Tissat to pass among you with our microphone. But can I just, before we do take audience questions, you mentioned other countries, and for instance Canada, I gather from an article you wrote last week, also had a number of unsuccessful prosecutions, and there were civil ways of trying to deal with this. For instance, the way in the United States people would lose their civil rights and be deported. Yeah. So what is the context for whether this worked anywhere in the world?
Well, it's a good point, because when the inquiry which recommended the change of law in 91 considered all the various options, one of the options they considered was using civil law to denaturalize some of these people, because most of them had lied on their immigration forms when they'd arrived in the aftermath of the war. As I said, they either claimed to be Poles, where many of them weren't, or they'd sanitized what they'd done during the war. So that's the reason that the United States, the Office of Special Investigations, which is their Nazi hunting unit, has managed to strip, I don't know the latest figure, I think it's about 150 people over the years, of their citizenship and deport them. And one of the reasons that we didn't do that was that this inquiry that recommended our change of law decided that that wasn't sufficient punishment, that only the use of the criminal law would be sufficient. Now, it seems to me that if you say to someone who's lived in a country for 50 years, and they're now in their 70s or 80s, we are going to deport you to a country that you haven't lived in, that strikes me as quite sufficient punishment.
Okay, we have an audience of distinguished people and also specialists in subject, including law and HSPS and others. So who'd like to come in with the first question? Yes, the gentleman there in the Selwyn colours, it looks like, but
Yeah.
okay.
I wanted to ask whether Britain didn't pursue with as much vigour as, let's say, France, because they didn't feel as if they had war guilt. They didn't feel as culpable as perhaps France had done, for example, after the war, and there wasn't the same impetus because of that.
Well, it's true that, Britain had never been occupied during the war. There was a huge amount of war weariness. You mentioned France. I mean, the first case, the first trial that got me really interested in this whole issue of prosecuting war criminals was the Klaus Barbie trial, because I was based in France at the time and covered the trial. And I think France was very reluctant, actually, to pursue some of these cases because it would lift the veil on Vichy and that whole collaboration era within France. So I don't think it's true to say that the French had any great enthusiasm, not until the 1980s, actually, when Barbie was finally extradited from Bolivia and stood trial. And then very belatedly in the 90s, when one or two people who had been very friendly with Mitterrand were outed and prosecuted, the police chief of Paris and so on. I think Germany, obviously, is probably the best example of a country which felt a moral responsibility to put people on trial, but actually didn't do very well at all until after the Eichmann trial in 1960, when there was a wave of concentration camp trials from the 60s onwards. But very few countries using the criminal law have been successful. We were not the only, I say we, I mean, the UK was not the only Commonwealth country to change the law. Roger mentioned Canada, Australia did as well. Australia also didn't achieve a single conviction. New Zealand did. So we were the only, actually, we did a lot better than any other Commonwealth country. We did actually get one conviction.
Anna. This is Professor Anna Philpott, who is head of the Biological Sciences School, Selwyn alumnus. So,
did any of the countries where the crimes were committed try and get the people extradited from the UK to those countries to stand trial in the countries where they did the crimes?
Yeah, good question. Well, not only the Soviet Union. And the Soviet Union, I mean, if you read the book, they're on between 1947 and the passage of the War Crimes Act in 91, there were 13 requests by the Soviet Union to extradite people that they knew were living in the UK. And the intelligence that they had was remarkable. The Soviets, latterly the KGB, knew well before the police in this country where some of these people were living. And there were these regular extradition requests made over that period. They were always rejected on the grounds that we didn't have an extradition treaty with the Soviet Union, and in any case, even if we had, they couldn't possibly get a fair trial in that system. The irony is that a lot of the evidence that was supplied by the Soviet Union to other countries, Poland carried out war crimes trials in the 50s, and the Soviets supplied evidence elsewhere, often to the Americans actually, was wholly accurate. There was no case that I know of where which the Americans brought against people living in their country, where they used Soviet evidence collected after the war, where any of it was found to be inaccurate. But all of those requests, as I say, were turned down on the grounds that they couldn't get a fair trial.
questions, please.
Someone there.
This.
There's been a recent case in Canada where they invited a former Ukraine, I think it was SS volunteer, to the Parliament, and it was seen as a big scandal, and the Speaker of the House in Canada resigned over it, that they hadn't done their research. And I want to, the cases you mentioned, Latvia, Lithuania, how have these sort of post-Soviet or post-communist countries reacted to these trials? Because, of course, mid-1990s, they're becoming independent. When a lot of the people who were members of these SS volunteer divisions were nationalists in Ukraine, fighting against the Soviets who'd put them through the Holodomor, what was their reaction to these people who obviously had done bad deeds but might have found some sympathy amongst this sort of wave of nationalism?
Yeah, that's a very interesting question. Well, it's a question in two parts. I'll try and be as brief as I can because it's a big question when you deal with how some of these post-Soviet states have dealt with these people. Just the first part of your question, though, is interesting about Canada because as a result of this case that you mentioned, this Ukrainian, who's now, I think, 98, they are talking about declassifying a secret report that was done by the Canadian War Crimes Inquiry back in the 1980s. And if they do that, that might put pressure on the authorities here to declassify the secret annex to the report that was done here, which set up the War Crimes Inquiry. It's never been published. And one of the reasons that I think that drove us to write the book was the cause of transparency, that we still don't know, 30 years later, who were some of these people and why the decisions were taken that were taken. And the files on them are closed until 2034 if you go to the National Archives. There's no particular reason for that. I mean, they're all long, long dead. And even some of their, the second generation are dead. So there is a lack of transparency here. Just briefly, though, dealing with the post-Soviet states, some, like Latvia, have actually gone in the other direction. They've rehabilitated or attempted to rehabilitate people that, say, fought for the Arras Commando on the grounds that they were patriots. Rather than murderers. And they haven't shown any great enthusiasm for prosecuting people that supported the Nazis, but they have shown enthusiasm for prosecuting or taking action against people that were pro-communist. So, there is this whole issue of the double genocide, people that were victims of the Nazis, and then before that, victims of the Soviet Union, and after that as well. So it's a complicated issue, that, and it probably needs, another book entirely. But
we'll come to one of our fellows, Dr. Haustein, in a minute. Let me just pursue that, though, because as I understand the Canadian case, this was actually celebrating Ukrainian patriots who actually, of course, were fighting against the Soviet Union, but therefore were on the side of the Nazis. So that shows, I suppose, all the different levels of moral ambiguity that there are in this. And especially, I suppose, now when we're particularly aware of the context of Ukraine and the Soviet Union, it's tough to... I don't know, is it tough to be too judgmental?
No, I mean, I wouldn't be. I can understand the motivation for people, I mean, if you look at the reasons why some of these people did join these militias, they were passionately anti-Soviet. And during the period of Soviet occupation from 1940, after the Hitler and Stalin Pact, some of these people and their families had been treated appallingly. They were sent to Siberia, some were killed. So you could understand their reasoning for saying, well, the Nazis have arrived, we'll treat them as liberators. However, they then went on to commit murders that were not defensible after that.
Jörg Haustein, right down the front here on the... if you throw it over, that'd be...
Whoa.
Oh, pretty good. I think that's a very good catch by Jörg. Yeah.
Thank you so much for this fascinating talk. I have a slightly philosophical question. I grew up in East Germany, and a lot of hay was usually made, that there was a lot more prosecution in the East, whereas West Germany had failed in prosecuting and sort of ridding lower echelons of collaborators. Now, of course, the irony wasn't lost to us that this was only possible under quite ruthless judicial systems. Is it the political side that people were afraid or took their eye off the ball that these things weren't prosecuted more in the Western world, would you say, or is it more the sort of more scrupulous judicial systems that then failed? Where would you put the emphasis?
Well, yeah, that is an interesting question. I think, as I said, there wasn't a great deal of political will for many years. I mean, even though this country was aware that there were trials going on in East Germany and indeed in West Germany, but the sentences given particularly in West Germany were almost derisory. People, and so many former Nazis were given their old jobs back and became judges and lawyers. But again, one could have an argument, it's the same argument that was used when the British and the Americans overthrew Saddam Hussein. Do you get rid of all of the people that were within the hierarchy and ran the civil service and everything else, and the country collapses? Or do you reinstate them? And I think the view was taken in Germany, look, we need these people to run the machinery of government. I don't have any great view about the sort of philosophical reasoning why there weren't prosecutions. I think the feeling was we've got other priorities now. I think, Germany, East Germany, never really fully addressed. I think it took the view almost like the Austrians. We were almost victims rather than, perpetrators. Austria was allowed by the Allies to claim victim status when some of the worst Nazis were Austrian, as we know. But I'm not sure that East Germany, the reason that there is, the AfD and some of the pro-Nazi groups in Germany are stronger in the East, and Saxony may well relate back to the post-war period, but you may take a different view on that. I'm not an expert.
Do you take a different view, Jörg?
Partially. I think it's true that this sort of sense of a moral superiority in having dealt with the Nazi crimes meant that actual racism wasn't addressed in East Germany, and multiculturalism never really arrived when you looked at where international students were. I don't think it's so much a matter of the victim mentality, though, because I think denazification did happen and went quite deeply in the term where people collaborated. And, of course, many people had fled. So in some sense, it also looked like it was a political split, that those people who were afraid of the Soviet Union for good reason went elsewhere, not just West Germany, but also Latin America and other places in the UK, whereas then East Germany could sort of take the moral high road that the people who had remained or were found out were prosecuted, sentenced, and then later issues with right-wing ideology were never addressed. And then, of course, the rise of the AfD is a lot more complicated. It has to do with the fall of the wall and the way East Germans feel that they've been left behind by what happened next.
Yeah. No, I certainly wouldn't argue with it. As I say, I'm not an expert, and you know much more about Germany than I do in relation to these cases. But yeah.
On the point you're making, John, about the extent to which the judicial systems in the West may have been softer, for use of a better word, you do actually quote the Senior Treasury Counsel about one of the cases where he says, "We didn't anticipate the defendant would put forward a defence that he was unfit to stand trial. But if the charge is that we bent over backwards to favour the defendant, I can live with that." That's quite a thing to say, isn't it? When you're talking about the horrific nature of these crimes. Yeah,
I was very much struck when he said that. in fact, I was thinking about it. I mean, this is a totally different sort of context, but, you know, all the scandal recently over the post-submasters and mistresses, and the fact that there was a desperate urge to prosecute, and there was no consideration given to anything other than that they were guilty of crimes. Whereas the line that you've just quoted, Roger, and the view taken by Treasury Counsel was, we've got a responsibility to both sides here. We've got a responsibility to see this in the round and not prosecute unless we are convinced that you know, there is a very, very strong case. Now, I think he was wrong in that case, but you can't argue that you know, his view, and I think the view of a lot of other lawyers, is we needed to be scrupulously fair. These were unique cases. We needed to give the defence every possible charge to put its case, and if it led to somebody actually getting off, so be it.
We've got less than 10 minutes, so make sure if you want to ask a question, please do signal now. We've got 2 questions down on the front row here, so...
All right. Okay. Thank you so much. Thank you so much, Professor. I'm just wondering, the question of guilt came up earlier, and Vichy came up earlier, and I would really agree with the question of the kind of non-prosecution of criminals in France and Italy as related to kind of the unveiling of the guilt of Vichy France, and I think, you know, from a cultural studies point of view, and there's a lot of evidence around this similar idea in Italy as well. You know, Italian people are good people; they didn't do anything bad, and so I find that really important, and in that case, the question of the legal recognition of the deportation of victims is important as well. And so I've been finding that in France and Italy, in some cases, the deportation was not legally recognized and kind of left, you know, in a non-recognized kind of way after the war, and survivors kind of had to deal with that and were campaigning for their this recognition. And so I'm just wondering whether there's anything around your research that you could link to the hospitality provided for victims and refugees in the UK, and whether you found anything about their legal status that might be kind of put in parallel with the status of criminals.
Oh, that's a difficult question to answer. I mean, the only thing I would say about refugees that came to this country mainly before the war, or when the war, you know, was in its very early phases, was that I think Britain has almost traded on its hospitality towards both Jewish and non-Jewish, but particularly Jewish refugees with the kinder transport and so on. And, you know, this film that's out, One Life, about Nicholas Winton, who, you know, was a remarkable man. I met him at one time. And I think that people tend to forget that immigration policy in this country during the 1930s was incredibly harsh. And the kinder transport actually was not even a government initiative, it was a private initiative. Okay, there was a cabinet decision taken to allow these 10,000 Jewish children to come here, but I think that we have, it's part of this, you know, mythology, if you like, of Britain standing alone against the Nazis when, you know, we weren't standing entirely alone. We did have what was the British Empire at that time on our side, without diminishing, the remarkable heroism of Britain in 1940. But I think a mythology has built up about Britain, its hospitality towards refugees, which is probably undeserved. But I don't know enough really about the hospitality of other countries. I mean, I know a certain amount about France, and obviously its attitude towards non-French Jews. The Polish Jews who'd come to France were the first to be deported, and then they moved on to Jews who were French citizens. So the French did have a very hostile attitude, but we interned thousands and thousands of Jews in the Isle of Man, or sent them to Canada or Australia before. And interestingly, some of these people, some of these German-speaking people, when they were eventually allowed to join the army, became war crimes investigators and were some of the most effective war crimes investigators, actually. But, you've raised a big issue that I don't really go into very much in the book.
Thanks so much.
And just pass the microphone next to you, and that would be...
You were mentioning that, in terms of the collaborators coming to the UK originally, you mentioned sort of lying on forms and people, like the authorities sort of turning a blind eye to investigating it. But were there any cases of British authorities knowingly allowing collaborators or war criminals into the UK while being fully aware of their history?
Well, there was, the one case which was prosecuted where I said that he had Alzheimer's and it never came to a full trial, he was actually investigated in this country by MI5 in 1947 because there were allegations made against him by people that had known him in Belarus, and he was investigated, and I think there was a lack of will to really pursue it, and the feeling was that maybe there was an ulterior motive in making the allegations, and he was allowed to go free, and he lived here for another 50 years before being prosecuted. As I say, the only two cases that I've come across where there is documentary evidence that MI6 were involved in them coming to this country were two members of what was known as the Caucasian Company. They were Georgians, and they were strongly anti-Soviet, and they fought with one of the Einsatzgruppen, Einsatzgruppen D, which murdered thousands in Crimea. They were protected to a certain extent by MI6, but there's no evidence that they weren't prosecuted because of MI6 involvement. So, it would have been very nice to have found evidence. It was suggested that the man I mentioned in Scotland, Antonas Gekas, wasn't prosecuted because during the miners' strike, I said that he was a coal board manager, that he'd given evidence to, passed on information to MI5 during the miners' strike. Again, this was a rumour, there's speculation. I've never seen any, written documentary evidence that that's true. So, no, that issue of, collaborators being protected remains unresolved, and until all the files are released and until all the secret parts of reports that have never been published are published, we will probably never know.
John, just a final question from me. Having worked on this issue for decades and now written a book, does it leave you feeling angry in any way? Because after all, what we're talking about is people who committed terrible crimes and war crimes and killed people who in the end never faced justice.
Interesting question. Well, no, and you might be surprised that I say that. I'm Jewish, so I ought to. I've adopted the same sort of attitude as I did when I was a journalist and I was investigating these cases when I was at the BBC in the 1990s. I thought that I needed to be as dispassionate as possible to consider the evidence, in the round, not report anything that I couldn't actually substantiate. And the book has been written in exactly the same spirit. And I reiterate, it's not a polemical work. We're not arguing that these people should have been prosecuted, but we're saying, look, read the book and you make a judgment on whether some of these people should have been prosecuted. We're just saying, well, perhaps they could have been.
John, before I thank you formally, can I just note there is actually a Holocaust Memorial Day lecture in this auditorium next Wednesday. It's organised by the university, so have a look at the university website if you want more details on that. The next Selwyn event in the auditorium will be on Tuesday next week, when one of our alumni, Shihab Khan, who's a reporter for ITV News, will be showing a film he made about a journey to the Hajj, which is an incredibly rare thing to be able to film and photograph, and Shihab's personal journey there is, I think, extraordinary, and I saw the film when it went out on television. So Shihab will be talking about faith, television and me next Tuesday at 6 o'clock in this auditorium, with a showing of his ITV film, which lasts about half an hour. So that on Tuesday, and the Holocaust Memorial Day lecture on Wednesday in the auditorium next week. John, thank you for an incredibly clear exposition of very difficult and complex issues. We're extremely grateful. Thank you for being a proud Selwyn alumnus and for contributing to a very important bit of national debate and our collective memory. So thank you for that. Thank you for being here tonight, and we really appreciate it. Thank you.
Thank you. Do go into Heifers and ask for the book.